find yourself in an accident, a victim of another driver's negligence. Might sound crazy, injured on the go, just call Mo. Call Mo.
Good morning, everybody, and welcome to another episode of Monday Morning with Mo. I am Mo DeWitt, an attorney, and we're here to answer your legal questions every Monday morning, bright and early at 8 a.m. So go ahead and give us a call. Leave us a voicemail, 407-536-6737. You can also text that number or shoot us an email at askask@dewittlaw.com. Hope everyone had a great weekend. Halloween, obviously, on Saturday. At least around here weren't many trick-or-treaters, so hopefully maybe you guys got some. I know there's a lot of drive-through events and stuff like that, so hopefully the kids still got out some one way or another and did it safely. But anyways, let's jump right into it, get to some of the legal questions that we have for this week. So first up is Kyle, and I will say I thought Kyle was messing with me on this question, but we'll go ahead and read it and tackle it anyways. So Kyle asks, hey, say someone at the Social Security office messes up and marks you as dead when you're still alive and it still hasn't been fixed. Is there anything you can do in ways of legal action to get them to speed up the process? So I completely thought Kyle was messing with me. But I actually looked this one up a little bit, and apparently about 7,400 people a year are improperly marked as dead through the Social Security office. Typically what you have to do is go to the Social Security office with one form of ID, and they basically issue you an official letter that says you're not dead, that you can then go and take to all your financial institutions to get this information corrected, as well as they correct in the Social Security database. So I don't know if this was a hypothetical on Kyle's part or if this really happened to him or someone he knows. But that's basically what you have to do. As far as getting it done faster, I'm sure, especially with COVID right now, if that were to happen to you or did happen to you, things probably are slowed down. It's probably more difficult to get accomplished. Personally, I'm not aware of any legal action that you can bring against the United States government to correct that. So I don't know that there's anything that much you can really do to speed things up. That being said, just be persistent, I guess. Keep calling them. And once they issue that letter, it should be fixed, but I would keep calling them until you get that letter. And they may need satisfactory proof that you are still alive, so that may be an issue as well. So I don't usually look up the questions beforehand, but that one, I did think you were absolutely messing with me. You still might be, I don't know. So anyways, thank you for your question, Kyle. Let's see here. Let's go ahead. We'll go to the voicemails next. Again, you ever have any legal questions? Give us a call. Leave us a voicemail, 407-536-6737. Or you can always shoot us a text to that number. Or even shoot us an email. askask@dewittlaw.com. Always happy to answer your legal questions. So let's take a look here. You got one voicemail, so let's go ahead and play that one.
Hi, this is Chris in Port Orange. I'm wondering why, with so many divorces and so many costly divorces, why we can't consider a 5-year marriage contract conception. Excuse me. Well, that's what I meant to say. You know what I'm going to do? Please forgive me. I'm going to call back and leave a different message. I'm so sorry.
No worries there, Chris. I appreciate you leaving the voicemail. Anyways, and you didn't call back and leave a second one, so we'll go with this one that you did leave. The law is the law. I'm not here to try to guess why the law is the way it is. I mean, I could make some, in my opinion, pretty educated guesses as to why we have the laws regarding marriage the way we do. But the short answer is, you can do a 5-year marriage contract if you wanted to. That's called a prenuptial agreement. So you can basically build into a prenuptial agreement almost anything you want with the exception of aspects that have to do with children. Typically, those are left aside. You can't really negotiate those when it comes to child support or time sharing or custody issues. But anything else, you could really go ahead and build into a prenuptial agreement. So if you wanted to have a contract that said, hey, we're going to be married for 5 years. At the end of that 5-year period, we can either agree to split all the assets we've acquired during that 5 years and terminate the marriage, or we can sign on for another 5 years. Or you could say, hey, after the 5 years, whatever's in my name is mine, whatever's in your name is yours, and the marriage is terminated. We agree to go through the proper steps to file for the divorce paperwork and all that kind of stuff. But you could absolutely, do something similar to that through a prenuptial agreement. Now, the reason I'm going to guess that we don't have something like that in place is because it could create an imbalance in power. So if the law said, hey, you guys are married for 5 years. After that, you just walk away. No one's entitled to anything. Well, now we have a situation where, one party may stay at home. That you guys may have accumulated assets, together as a family, and they may all be in one party's name. So it could create some inequities, at the end of that 5 years. People may handle things differently. The other answer is just don't get married. A lot of couples, live together as couples, but they don't get married. They don't have that, sort of legal contract between them, and that's how they handle it. So, I appreciate the voicemail. I appreciate the call. But, you could do a prenuptial agreement if you wanted to get married, or just not get married, and that would kind of solve the problem there. But, that's why I think we don't have that. Obviously, we could probably spend a few hours discussing, the theories and what all goes into that and the problems that could occur if we didn't have divorce laws the way they are. But we'll save that for another show, maybe a more in-depth show. So anyways, thank you, Chris, for your call. As always, any voicemails, give us a call, 407-536-6737. Fun little piece of information. That's actually 407-53-MOSES. Give us a call, leave us a voicemail, shoot us a text to that number, shoot us an email, ask@dewitlaw.com. A lot of people like doing that. So like I said, every Monday morning, 8 a.m., we are here, we are live to answer your legal questions, start your week off right, and get you going in the right direction. So let's go to the next one. This is from Jamie. It actually came in during last week's show, but I wasn't really able to answer it. It's hard to read, type, and talk at the same time, I find. So if I don't respond to your legal question right away, I apologize. All right, so Jamie asks, what happens if my dad is in a medical malpractice suit over my mom's death and he passes away? Does the lawsuit disappear? Great question, Jamie. Absolutely, it does not. So if one party dies, so if you're bringing a lawsuit and you pass away, what happens is your estate is substituted in on your behalf. And so typically, I think it's either 60 or 90 days. I don't remember off the top of my head. But basically, you have to sub in the estate for that party. You just sub them in, and then the estate is now bringing the action. So really, it's more of a procedural issue at that point. But the lawsuit just doesn't go away because that party passed away. So now the claim belongs to the estate. The estate can pursue the claim, and if there is a recovery, the recovery would go to the estate. So if there's a monetary recovery in a medical malpractice case, if they are able to sue and win and they get a judgment and get paid on that goes to the estate and then is distributed through the estate. So if there's multiple heirs on the estate, then it would be distributed accordingly. So great question. Always appreciate it. Keep them coming. We like answering them here, and it gives us something to talk about here. So let's see. Next question here from Bob. If I paid cash for my girlfriend's car and she left and took the car, can I get it back? I just put the title in her name. So what do you think, Bob? You think you can get the car back? Unfortunately, no, Bob, you cannot get the car back. That is called theft. That is stealing. So if the vehicle is in her name, is titled in your girlfriend's name, even if you paid for it, it is legally hers. You can't just go pick it up. You can't just go take it. That would be a crime. Now, if you had some sort of verbal agreement with her that she was supposed to repay you the money, you could still sue her for breach of that verbal contract. If, if she was supposed to pay you down the road, you could sue her for that verbal contract. If it was just a gift and you gave it to her, that's a gift. Just because you broke up doesn't mean you can take the car back. So, in the future, if you're purchasing a vehicle with the intent to allow the other person to use it, but you want to retain ownership rights to it, make sure you title in your name. Because basically that's whoever it's titled to, that's who owns it. So, yeah, you can't just go pick up the vehicle. Don't do it. You will be committing a crime if you take someone else's vehicle that's titled in their name, even if they owe you money. So bad idea there. But thank you for the question, Bob. And let's go to the next one here. So Maria asks, I was separated from my husband in 1985. I've lived in Florida since 1997, but never lived with him in Florida. Can I file for divorce in Florida? So, my first question would be, where's the last place that you guys lived together as husband and wife? Typically, that's the place that has jurisdiction for the divorce. If he still lives there, you're most likely going to have to go back there and file wherever you guys last lived together as husband and wife. But sometimes what happens is, well, I'll just make up a state. Let's say you both lived in Georgia before as husband and wife. You guys separated. Wife moves to Florida. Husband moves to Arizona. So now neither party lived where you guys last lived together as husband and wife. So typically in those scenarios, one party is going to file in Florida, one party is going to file in Arizona, and then it's kind of going to be up to the courts to determine who has jurisdiction. Clearly, it's not really convenient for you both to have to go back to Georgia. As far as jurisdiction goes, if you've lived in Florida for more than 6 months, you can file the divorce. It would then be up to the other party to essentially challenge it and say that it's not a convenient forum for them, and the forum should be wherever they're going to argue it's going to be because of X, Y, and Z. They have to give their reasons at that point. So, short answer is, hey, if you've been here 6 months, you can file. Court has jurisdiction, but typically the proper venue is going to be where you last lived together as husband and wife, unless neither party lives there anymore. And then it becomes a little bit more of a complicated analysis. So, again, great question. Greatly appreciate it. Keep them coming. Shoot us an email at askask@dewitlaw.com. Give us a call. Leave a voicemail, 407-536-6737. Beautiful numbers on the screen there, so you can find it easily. And, of course, you can text that number, too. So I think we got one more question here before we let you get on your way. So let's see here. Carl asks, if I'm on the birth certificate of the child I had with my girlfriend, do I have any rights to see the child? She is currently saying I have to text her in advance to get permission. What do I have to do to legally have rights to see my child? All right, so I talk about this a lot because I think it's a common misconception in Florida. If you are not married to the mother of your child and you guys have a kid together, even if you're on the birth certificate, you haven't been adjudicated the father, which basically means a court has to say that you are legally the father of that child, even if you're on the birth certificate. So in this case, where the mother is refusing to give you time sharing, the only thing that you can do is go and file a paternity action. And a paternity action basically does three things. First, it adjudicates you as the father. So a court legally establishes that you are the father of that child. Second, it establishes a parenting plan, which is going to give you custody rights, which we refer to as time sharing in Florida, and it's going to establish child support. And really, a lot of judges will say that you really should do file a paternity action as soon as the child is born if you're not married, because we've seen a lot of horrible cases, frankly, where the parties were living together. They were never married. Paternity was never established. Mom picks up with the child, moves across the country. There's nothing dad can do to get the child back in the state of Florida. So a lot of kind of crazy things can happen. And basically you have no legal rights. A father has no legal rights until a court legally establishes and adjudicates him as the father. So it can be a very tough position to be in, because there's nothing you can do. There's nothing you can do until you're legally established as the father, until a court adjudicates you as the father. So great question there, Carl. I recommend file a paternity action as soon as possible. And you can also do an uncontested paternity action. It doesn't sound like Carl and the mother of his child are getting along right now, but if you are getting along with the mother of your child, you can do an uncontested paternity action where basically you guys agree to paternity and agree to a parenting plan. Now, you still may have to do a DNA swab just to confirm it with the court, but it is an easier and cheaper way to do it, and that way you're legally established and legally adjudicated the father, and you have parental rights that way. So, great question, something we see in our office all the time, and I greatly appreciate all the questions that you guys keep sending our way so we can keep doing this show every Monday morning at 8 a.m. and answer your legal questions. If there's ever anything you need during the week, shoot me an email, give us a call. We're always around, able to hear it and trying to help you any way we can. So, if you're still watching through this far on the show, again, thank you. Thank you for watching. Thank you for your questions. Have a wonderful week, and stay safe out there. So I'll see everybody next Monday morning, bright and early, 8 a.m. Take care, everybody. Up. Well, let's try it now. All right, 3, 2. Here comes the Mo animation. See you later.